Welcome everyone to Kay Altman Law's presentation on the who, what, where, when, and why, and how of due process. Thank you so much for joining us this evening. We hope you find it informative and that you go away with a little bit more knowledge than you came with. My name is Ashley Bennett. I am the Director of Special Education Advocacy for Kay Altman Law. And myself and my advocates will be presenting the webinar information to you. Before we go ahead and get started, I just want to point out up above your screen, you will see a little icon that says Q&A. And that is where you are going to click on that and enter in any questions that you have as we are going through the webinar. We will have time at the end for questions, and that is where we will pull from. Any questions that do not get answered at the end of the webinar, you will be receiving in a Word document or some type of document. Will give you all the questions that were asked with all of the answers, so you can look forward to receiving that. Don't feel like you have to go crazy taking notes, jotting down answers to questions, because you will receive them after the webinar. Okay. Again, thank you very much for joining us. We are Kay Altman Law. We are a national firm, and so we have clients all over the country. We have 4 main divisions within our firm: student defense, special education, Title IX, and civil rights. So those are the 4 highlighted areas where we all have experience, and that is mainly what we practice. So wherever you are in the nation, we are ready to help you. This is our team. I am not going to read you all of these biographies. If you are interested in our team and reading more about each of us individually, our biographies are available on our website. We have myself and then Nora Schumann, who is my Assistant Director of Special Education Advocacy. And then on this frame, we also have Sarah Lotak, who is one of our advocates. We also have Bobby Congdon and Eric Counts. So that makes up our advocacy department. And together we have well over 100 years of special education experience, both teaching and at the administrative level with districts. And we are all now in the advocacy role. And we also have our very own special education attorney, Nikki Camiso, works side by side with us every day. We have a very much of a partnership. When we feel like we need the assistance of an attorney, Nikki is always there for us. And she is also a wealth of knowledge in both student defense and special education. So again, her full biography is available on our website if you are interested in looking more into that. Okay. As we get into our content, our first presenter is Eric Counts, one of our advocates.
All right, thank you, Ashley. What is a due process complaint? A due process complaint, DP complaint, is a formal complaint regarding the identification, evaluation, or placement or provision of a free, appropriate public education, also known as FAPE, for a student with a disability or suspected of having a disability which may result in a due process hearing. The hearing may involve attorneys and advocates, such as us, for each side, and will result in a legally binding written decision that can be appealed to a court of law.
Okay.
What happens at the due process hearing? A DP hearing is conducted by an administrative law judge, ALJ, for the Office of Administrative Hearings, who will take evidence from both parties and render a decision regarding a special education dispute. For specific information regarding the due process hearing procedures and rights, please refer to the procedural safeguards in your state. Very important. That is your
Yes.
gateway and your pathway to all rights pertaining to students with disabilities. So please read those
Yeah.
procedural safeguards. They should be given to you prior to each meeting, and that should be one of the first things that you go over when a meeting first starts.
And very important to note that they do vary state by state. So you want to make sure that, like Eric said, you want to make sure that you get a copy of those right away.
What is the process, or what is the due process timeline, excuse me, if the public agency or school district has not resolved the due process complaint to your satisfaction within 30 days of receiving the complaint, which is also called the resolution period, the due process hearing may proceed. If a hearing should occur, the ALJ, Administrative Law Judge, has 45 days to conduct the hearing and issue a final decision. And lastly, the timeline for this type of decision can be extended at your school or the district's request. So you can request the extension and or the school district. However, it is important to recognize that the hearing officer has the ultimate discretion to deny any request for an extension.
Thank you, Eric. Okay, and next we have Sarah.
Okay, so why would I file a due process complaint? So there's a few reasons why you would go about filing. The first reason is if the school refuses to evaluate your child. So when you request an evaluation, the school must provide a written response, a formal response to that request. And if you disagree with that response, then you could file due process. If you disagree with the eligibility decision, if the school refuses to provide a related service, a modification, or a supplementary aid that you feel like your child needs, and if you disagree with the placement decision. It's important to know that some states can override that placement decision, so it's important, again, to check with your state on the specifics. Okay, another important time to file a due process complaint is when you are appealing an MDR decision. So if you don't agree with the manifestation determination review, it is your right to file a due process complaint with your state educational agency for an expedited due process hearing. In order to do this, you have to make the request in writing to both the superintendent and the state educational agency. It must be requested within 2 years of the MDR decision. Most, if not all, states have some documents and forms that can help guide you when making a request. And when a due process refers to a disciplinary action, like an MDR, the complaint is fast-tracked to an expedited due process. And these timelines do vary by state. So again, check with your procedural safeguards within your own state.
And Ashley, if I can just interject, folks, just to let you know,
Absolutely.
if the manifestation determination review, which is typically held when a child is found to be in violation of some student guideline or policy or district policy, if that is determined not to be a manifestation and you plan on appealing, make sure to keep the district updated immediately that you're appealing it, even before you file, because they will continue on the disciplinary end of things to try and proceed with whatever recommendation has been made.
Thank you. Yep, super important. Okay.
Okay, so who can file a due process complaint? Both the parent or guardian or the school district can file a due process complaint. The complaint must be filed within 2 years of the action that is the reason for the complaint itself. And there are some exceptions for this timeline, so please refer again to your state's procedural safeguards.
Okay, thank you, Sarah. And now Nikki is going to tell us a little bit about how due process hearings and court proceedings are actually quite similar.
Yes, unfortunately for most families who are completely caught unaware, you would think that filing an appeal from a manifestation determination that is not in your favor would be a simple process. It really isn't. Due process is very involved, complex, and can be litigious in nature, which means very adversarial. It is certainly much more formal than you're used to. A due process hearing or due process itself, the pre-hearing process, is almost identical to moving forward with litigation in a courtroom. There are two different kinds of timelines. One is both move quickly, right? So one is typical, as was first described by Sarah, typically sets forth approximately a 40-day time period, unless the parties agree to mediate. Both parties have to agree in order to move to mediation. If the parties do not agree to mediate, the administrative law judge or hearing officer can schedule a resolution. And if nothing happens with mediation or resolution, it becomes, some states have expedited tracks regardless of why. They just push it forward within, let's say, a 14 to 20-day time period. Either way, your preparation time, and that's another distinctive characteristic of due process, is much, much more abbreviated than it would be if you were preparing a case for trial in court. Okay. And that includes all pre-trial or pre-hearing activities. Both of these take place in a formal legal setting, right? So whether it's in a courtroom or in a building such as a district sort of conference room with an administrative hearing judge, it is a formal process. There are some states, some districts that will permit you to participate in the hearings remotely, the same way that oftentimes you do with a manifestation review or a disciplinary hearing. But increasingly, we are finding that a lot of these, the administrative law judges are asking for in-person appearances. In terms of pretrial, pre-hearing process, if you don't resolve at mediation or resolution, it runs the full gamut, only on a very short time frame. So pre-hearing motions, objections, the district can move to essentially dismiss the due process complaint for failure to state a claim. And then you have to respond to it, and oral arguments have to be presented. There are scheduling conferences. You have to notify and prepare your witnesses. You have to give witness lists. You need subpoenas in order to make sure that the witnesses show up for the hearing. You have to get the administrative law judge or hearing officer to approve the witness list. You have to submit proposed exhibits and evidence and make sure that you have witnesses that are sufficient to get that evidence in at the actual hearing. Because even though the judge may say, yes, this is all evidence that's relevant to the case, if you're not familiar with how to introduce evidence at a trial or at a hearing in front of a judge, it's called lay a foundation in legalese or a legal term of art. If you don't know how to get it in, you may be stuck with not being able to present it or make that argument in front of the administrative law judge, even though he or she may know that it exists, right? So it does become very complicated. In any event, you prepare your exhibit lists, your witness lists, exchange them. You then have to present objections to your adversaries, which in this case would be the district, right? To any alleged evidence or exhibits that you think are not relevant or more prejudicial. And the proposed submissions are then taken in, organized, and presented at a hearing, which can range depending on how complex the case is. It can go from 1 day to full hearing, 3 to 5 days, sometimes longer. As with the pretrial mechanisms, there are opening and closing arguments. Standard with, I'm sure most people have watched things like Terry Maguire or Time to Kill, right? Everybody loves those movies. There are opening arguments. They're not really arguments. It's where you lay out your sort of case plan. You sort of give the lay of the land, what the evidence is going to prove. In this type of hearing, the standard of evidence is preponderance, which means is it more likely than not that the violation of federal law occurred. And it's not the same as a court of law, which is a bit higher, especially in civil court, right? Preponderance is lower, but it is still difficult because the district only has to meet that minimum requirement free and appropriate public education with the least restrictive environment. It doesn't necessarily have to provide for all of the services that you think or that we believe your child is entitled to. Closing arguments, by contrast, are more persuasive, and they are intended to pull together or tell your story of the case, right? Bring everybody together and convince you're trying to convince the administrative law judge why the law is on your side, why the violations have actually occurred, and why the relief that you're requesting is both reasonable and appropriate. The presentation of evidence throughout the case in chief, which is, the body of what you're doing, involves presenting witnesses, direct examinations, cross-examinations, same way that it does on Law and Order, right? To sort of just make it easy to understand, asking the right questions, making sure that you ask the questions so that the evidence can be submitted. For example, if a social worker wrote an evaluation, you can try and submit it as a business record, but it's certainly much better to have that social worker there to testify, to present the business record and to talk about what is discussed in the business record. There's always a possibility that something in the record might be kept out if that person's not there to testify. So there's a lot of preparation involved. And ultimately, that administrative law judge or hearing officer will make a ruling or a decision based on all of the evidence presented and the opening and closing arguments.
Thank you very much, Nikki. I know it's a lot of information to take in. This is very important, what local level options are. When parents consider filing a due process complaint, if they were to contact an attorney or speak to someone about filing that complaint, any good attorney should tell you, have you exhausted all of your local level options first? A due process complaint procedure is very overwhelming. It's very damaging to the relationship between school districts and parents. And not that it is not warranted at some point. However, it is super important to exhaust all of your local level options. So what does that mean? Have you tried reconvening the IEP team? Have you requested a facilitated IEP meeting through your state's Office of Dispute Resolution? Important to note that not every state offers this. So it does vary state by state, and both the parent and the school district have to agree to a facilitated IEP. And what that is a third party coming in from the state, doing exactly what it sounds like, facilitating the IEP meeting, hearing both sides, trying to get both sides to compromise. So that is an option. There is also, in some states, again, you have to look and see what your state options are. Sometimes the Office of Dispute Resolution will allow for a state-run mediation. There is a mediation as part of a process of a due process complaint. However, you can also do a standalone mediation depending on your state. And that's another local level option. It's a little bit more involved than a facilitated IEP. And at the end, you reach a mediation agreement. So there is a written agreement at the end of that mediation. You can also, some states offer state facilitated resolution sessions. Again, that is also part of the due process procedures. However, some states offer that as a standalone option. So these are all opportunities for the parents and the school district to come together to compromise and to make the offer of FAPE for your child. If none of these processes are successful, then the parent or the school district may consider filing a due process complaint with the State Department of Education. One thing that we run into quite often is that parents call us after they've already filed a due process complaint. And what happens is they start getting emails asking for their witness lists, their exhibits, their subpoenas. And then they think, oh boy, we need to call somebody. So you do have options. If you have filed a due process complaint and you still would like to explore your local level options with advocacy, with an advocate, there are things that we can do to make sure that we can explore all of those options with you. Due process complaints can be withdrawn and they can be adjourned. It just depends on your ALJ and it depends on your state. So there are ways for us to work around that to offer you the opportunity to come to some sort of agreement with the district. And that's what we strive for as advocates, is to come to some sort of an agreement before we get to the due process. Just again, such a daunting task that, nobody really wants to pursue that unless it's absolutely necessary. So I kind of just went over a little bit of some ways that we can help. When you call in for a consultation and we provide you with a scope of service, we give you basically all of these items that are showing on your screen right now. This is the minimum that your package would include. We will be involved at the local level to try and remediate the problems with the district before it gets to the point of needing to file due process. We review all of the documents, current evaluation, current IEP, any medical documentation that may be relevant, IEP progress reports. So we do a deep dive into your child's documentation prior to attending any meetings. We attend all local level meetings remotely. That includes facilitated IEPs, mediations, resolution sessions, or just regular IEP meetings. We attend them all remotely. If we need to, if this is not already set up, we will reconvene the IEP team to discuss your child's ongoing educational programming. We have no problem establishing communication with the school districts and also letting them know that we now represent you and kind of take a little bit of the stress off the parent. Of course, everything is done with the approval and the involvement of the parent every step of the way. We help you interpret evaluation data. If we do not agree with an evaluation done by the school district, we will request an independent educational evaluation at the cost of the district. So that is something we can pursue if we get some results that parents and advocate do not agree with. We finally make professional recommendations regarding services and programming to address your child's needs. With, of course, your involvement every step of the way, and hoping that, by having a friendly face going into the IEP meeting, that we will be able to achieve a favorable outcome for your child. That's our goal.
And if I can just comment as a sort of postscript to
Sure.
that, we've given a previous webinar this year that discussed when special education students are facing potential disciplinary retribution, so to speak, right? Where if it's determined at a manifestation review that it's not related, right? It's not related to the disability, or that it's not a failure of the school to implement the IEP, but really the evidence and the documents and the history support otherwise, right? You really do have grounds for a due process complaint. In addition to our special education services, we do offer student defense, and we've developed within the special education advocacy group, with the help of our student defense arm, a really unique approach to these kind of cases. And I try to be very interactive with Ashley and her team. The entire team is wonderful. So that if a child is facing, let's say, a principal or an assistant principal wants to expel a child, age 11 or 12, because, he's acting out in school, and really, what they should be doing is requesting additional evaluations because of a mounting sort of disciplinary history, right? They're exhibiting different behaviors because they're maturing. That manifestation hearing can be critical, because if they determine that it's not a manifestation and you have to appeal it and go the due process route, they will try to expel or place your child in alternative schooling or online learning while you're pursuing that. Altman, as a group, we have developed a unified approach, where I do become involved sooner than I normally do, where Ashley and her team usually spearhead, to try and cut off that disciplinary aspect of it. Because if we're successful at the manifestation, then you can just proceed in terms of making sure that your child has everything that our advocates will work on your behalf to achieve. And that is all of the supports that they're entitled to, all the evaluations that they need, as opposed to worrying about having this hanging over their head,
Right.
this potential disciplinary outcome that they really don't deserve.
Right. Yes. Thank you, Nikki. Okay. All right. I know that we just threw a lot of information at the audience. So we want to pause now and have some of our questions or some of your questions posed to us and see if we can't get you some answers. You're muted, Bobby.
Thank you. I apologize. We do have
Sure.
a couple, Ashley. So what happens when what happens to the child or the student while they're waiting for the due process hearing to take place? We kind of touched base on that a little bit, but if we can reiterate that for the parents.
Sure. Good question. So once a due process complaint is filed, that enacts the stay put, meaning that so if your child is potentially up for expulsion or transfer to an alternative school, once that due process complaint is filed, they have a stay put, so they stay in their current placement. Now, that also may mean in that current placement, we may need additional supports, right? So there's a reason that disciplinary things happen. But if, say, it's not disciplinary and we still have some disagreements between the family and eligibility or anything like that, the same rings true. We can absolutely request the stay put, even if we are having a facilitated IEP, mediation, or a state-run resolution session. It is not best practice to move a child while there is a question about evaluations or there's a question about services. Some districts will push back on that. However, we are prepared to do what is best for your child. So kind of a double answer there. But when a due process complaint is filed, there is a stay put order that begins right away until the end of the hearing.
Would that go along with if the parent is not in agreement with the placement or services that are currently in place before the due process begins?
So if parents have a problem with the current placement that they have previously approved, again, remember, you get that prior written notice at the end of an IEP meeting, and if it includes a change in placement and the parent signs that, then you are approving that placement. So if you have further questions, if you do not approve, then do not sign that prior written notice or notice of recommended educational placement. Different states call it different things. Do not sign your approval for that current placement or for the placement that is being proposed. If you run into the situation where you approve the placement, your child starts attending, and you are seeing things that you are not happy with. And that is the time to reconvene the IEP team. However, that does, if there is a due process complaint filed or a mediation requested or something like that, then yes, that child would stay put in that current placement until things are resolved at the end.
If I'm just not happy with the IEP services at all, is that a legitimate reason for me to even file due process?
Well, it depends. If you disagree with annual goals, modifications, accommodations, my answer would be no. That is not a reason to file due process. That is a reason to reconvene an IEP team, absolutely, and ask to take a look at the data. If you are unhappy with placement, if you are unhappy with an eligibility decision, if you are unhappy because a district refuses to evaluate your child, those would be reasons to eventually pursue a due process complaint after your local level options are exhausted.
So what does the family need to do to prove when the district is filing the due process, maybe because the district wants an OOD or the family wants inclusion. Or for whatever, how does the family respond once the district is the one that is starting the due process?
Right, and that is rare. It is rare for a district to file due process against parents or guardians. It does not happen often. But when it does, then the parents should absolutely seek out legal counsel, because that process is going to happen very quickly. And you want to make sure that you've got an attorney who is prepared to support you through that entire process. So yeah, you definitely, and that does not mean, even if the district files, that does not mean that you cannot come to an agreement at the local level. That is still a possibility. However, if a district does file against a family, I absolutely request seeking legal advice right away.
So is that something you could help with if if a district's filed due process on me because I was holding out on not agreeing to the IEP?
Absolutely. We would go about it just like we would with supporting any other type of situation. We would first exhaust the local level options. Of course, we would involve Nikki right away because we would want her to know that there is a due process complaint filed against the parents. And so we would involve her right away. So while we are exhausting all of those local level options and trying to come to an agreement outside of the due process proceedings, we would get Nikki involved right away. So it's a little bit different, but we would still do our part in trying to get things settled prior to having to go to due process. Even if the district files against a family, they still don't want to go to due process. And they will absolutely be willing to, most districts, I don't want to say all, most districts are willing to work with us to get a resolution prior to having to file due process or go all the way to hearing.
And
So
the reason that it's important at that point to make sure that you have legal representation is twofold. Number one, because the district's attorney will certainly be involved, right? There's no way that the district is filing due process, that their attorney is not spearheading it. Number two, it's because they believe that they have the law behind them. And while it is rare, we do have cases where the district has been the instigator. They are oftentimes, I'd say about 98% of the time, willing to go to mediation or resolution or state state-run intervention. But if you show up without an advocate and without legal representation, I can tell you that they will do their best to steamroll you. And if it does go to due process hearing and you lose in due process, as a matter of course, there is no guarantee that you're going to get back legal fees, right, or costs. The same holds true for the district. However, if a party, any party, is deemed to be the prevailing party, if you go through with a full due process hearing, let's say the district has filed due process against you because you don't agree and you don't want to go along with their plan, and an administrative law judge determines that they have provided a free and appropriate public education in the least restrictive environment and that they didn't violate anything and that the parents' demands were outside of the scope of the law, and the district is deemed the prevailing party, in theory, they can file in federal court to seek reimbursement of their legal costs and fees from the family. And that's a critical point that you should be aware of.
Yes.
So
thank you, Nikki.
thank you, because that wasn't the next question. It's really not advisable to try to, even though parents can be very well versed, it's not very advisable to go into a due process without legal representation. Is correct?
Yes, that would be correct. I would say that an advocate, a knowledgeable advocate like our staff can absolutely handle all of the local level options. We have sat in mediations for 6 hours with families and school districts and come to a favorable outcome for the child in the end, 8 hours even. So we can absolutely handle all of the local level options. Absolutely, if the family and the district are headed to that due process, our attorney is absolutely involved from step one.
And just to clarify what I'm understanding, Ms. Camiso to say is, you are not, even if you're victorious in your decision from the judge, you're not guaranteed your attorney's fees will be reimbursed, correct?
That's correct. There's no guarantee to anything. And in terms of advocacy, um, everything that sort of precedes. Now, there are some states that won't allow you to negotiate legal fees at mediation or resolution. There are other states that will. So it is possible to try and get back at least some of your money if you need to expend money in a due process pre-trial sort of situation. But there are no guarantees. It's just like going to trial. You can take the best case. You think you've got, this is the biggest case you've ever had, and you're sure the jury's going to rule in your favor. You may end up getting what's called no cause, no award at all. The jury may decide based on some point of law that you don't win. You may have the worst case in the world or think that you do, and you end up with a jury award in favor of the plaintiff. So there, unfortunately, when litigation is involved, and due process is a form of litigation, it's adversarial, there's no way to predict. So you're always taking a risk for sure.
Is there an appeal over and above if you lose your due process?
Yes, if you do not agree with the outcome, with the decision of the due process hearing, you can absolutely appeal. Again, those guidelines vary state by state, but you can appeal. And Nikki, maybe you would know this a little bit better than I would. If they are not awarded any type of reimbursement for any type of legal fees, can that decision be appealed?
Well, they won't be awarded legal fees in terms of a due process hearing typically. It can be mediated or agreed upon
Right.
if you don't go forward with due process. If you are not reimbursed for legal costs and fees through due process, whether it's by resolution or the hearing, and you are deemed the prevailing party, you can then file in court, whether it's state or federal, to try and get back all or a portion of your legal fees. But keep in mind that there are very few attorneys, and this is something that's very, very important to understand. There are very few attorneys, very few law firms that actually specialize in this area of law. Most are unfamiliar entirely. It's a very niche field. It's administrative in nature. And it's very challenging. And as I just said, legal fees are never guaranteed. So we're not, we're not hitting big, giant, multi-million-dollar plaintiff suits. We're not bringing in all this money. We do this because we believe in the cause and because we want to help people. And that's what our law firm stands for. So you can try and hire a local attorney, but odds are we've actually encountered people have come to us on the eve of due process because when it comes down to it, the nuts and bolts, when it's time to present a case for due process, local attorneys just don't know what they're doing. And at that point, it's extremely overwhelming and there's a lot of information to digest and it's hard to get that put off at that point, and even less likely that you'll recover legal fees. It's important if you're going to consult with a national firm like ours that you get us on board sooner rather than later so that we can file the appropriate motion to try and get admitted in your state to make sure that any efforts that we make on a legal basis above resolution will be considered legal fees, right? And not just advocacy. Because right now there is there's a bright line between advocacy and legal fees, and districts are pushing back even at resolution in terms of reimbursing costs. They always will, claiming that, tax funds are limited. So the sooner we get involved, the better off we are, and the less expenditure you can anticipate.
Right.
So what's the difference between expedited due process and due process? And when would a parent file one over the other?
Sure. So expedited due process typically comes into play when we have a disciplinary decision looming. So you had an MDR and you that was found to be not a manifestation of the disability. The parents disagree. They file for due process. In most states, I do have to say, in most states, that is the only option to appeal an MDR. There are some exceptions, so please make sure to check your state guidelines. But when you do that, when you disagree with an MDR decision, file a due process complaint. Those are expedited, and they're expedited meaning that it has to be held. I forget if it's 7 or 10 days. I think it's 7 days, if I'm not mistaken. In most states, they has to be held within 7 days because we're talking about a potential expulsion, a potential long-term suspension. So when you have that type of situation, that's what an expedited due process is. A regular due process complaint that is not disciplinary in nature is going to be the 30 to 45 to 60 day timeline.
So can you clarify then, the expedited due process is tied to an MDR, or it is only in some situations?
Typically, it is typically tied to an MDR. That being said, anyone can request an expedited due process. When you file, that is one of the questions that is asked. Do you wish this to be an expedited request? And you can select yes or no. So if you have a situation where you are really concerned about your child's placement, you can absolutely request an expedited due process, and then that will be up to the ALJ. They will make that decision whether or not this qualifies for something that is expedited.
So you could do that if you disagree with the MDR results.
Oh, absolutely. Yes, absolutely. You should.
Just be aware that if it's non-MDR related, requesting an expedited due process will happen very, very, very quickly. So if your child has a long history, several iterations of the IEP, if you want to get legal counsel involved, if you intend to call witnesses or try and get medical documentation, think twice about requesting expedited, because if you go normal track, you have more opportunities to resolve it with less financial investment and certainly less pain.
Mhm.
I don't know how else to put it.
Yeah.
Because going to full due process hearing and trial is a lot, so it's a lot in a short amount of time when you request expedited. And most people have jobs that they have to go to. Their kids are special needs and have, certain regimented schedules or medical needs that have to be attended to. And an expedited due process can be very challenging.
So a parent explains that he was in the middle of due process. They just got to a point where they decided they were going to put their child in private school. The case was dismissed. However, now the child's back in public school, and the child needs to be newly assessed. They would like to ask for an IEE. Does the due process start over for them, or how does that work? If you were in due process, it was
Sure.
dismissed, and can you come back at a later time?
So so there's a lot in that question. So first of all, if the child who is returned to the public school needs to be reevaluated, I don't know how many years were in between the private school versus going back to the public school. The first thing the family wants to do, of course, is request an immediate evaluation and have their child get a full psychoeducational evaluation to determine what services and supports are needed. If there would be the concern enough to file an additional due process, I think since it was dismissed, and correct me if I'm wrong, Nikki, but since it was dismissed, it would be a new complaint.
Yes, it would be. And you couldn't relation back because
Right.
more often than not, depending on how much time has passed, the statute of limitations in terms of what the alleged violation was is probably run. But even if it hasn't, at this point, the private placement acts as sort of, it's an intervening, superseding, it cuts it off, right? Cuts it in the middle. So now you're back. Now you have to have your child reevaluated. A new IEP or 504 behavioral plan, or all three, have to be created and implemented.
Mhm.
So there is no outstanding violation. You've dismissed the due process and moved your child and then brought them back. So you can't just reinstitute. You do have to go through the whole process and procedure of having your
Correct.
child evaluated and a new IEP created.
So if they were to decline the request for an IEE, they would basically go back through the process of reconvening the IEP and trying to work it out on the local level that was previously discussed.
Yes, well, you need to
Yes.
submit the full request, as Ashley mentioned, for a
Yeah.
full psychoeducational evaluation and functional behavioral analysis, along with an assessment for safety plan if necessary.
Yeah, you cannot, I mean, you can request an IEE standalone from a district. It probably will not be granted. You typically request an IEE if you disagree with the district's evaluation or they refuse to evaluate. So when you have those two situations, requesting an IEE would be the next step. It's not typical that a district would approve an independent, like a request for a standalone IEE.
Okay. So the question is, how are our advocacy fees paid? Are they paid by the parent? And how would a parent kind of get an estimate of what those fees might look like?
Sure. So yes, they are paid by the parent when they secure our services. We offer consultations, and in a minute, when we get to the last slide, you will be given a code for a discount on a 30-minute consultation with one of our advocates. We take a listen to your case. And we let you tell us what you have tried so far, what your goals are, what your desired outcome is for your child. And then what we do is we provide you with what our scope of service would be. And after every consultation, you get an email from us outlining exactly what we would provide. So it ranges, right? It varies depending on where you are in the process, what your situation is. So it's very individualized. Your scope of service is very individualized. And then we will let you know what that package price would be. We pay by the package, not by the hour, because our advocates stay with you from the beginning to the end of the process. So if it takes 2 IEP meetings or it takes 6 IEP meetings, we are with you through the entire process until an agreeable IEP is in place. That's why we offer scopes of service as opposed to billing by the hour, because it could be a month, it could be 6 months. We would rather make sure that you know that we are with you until an agreeable IEP is in place.
Okay, we actually have two that are very specific.
Okay.
Can we go ahead and, okay, so one is, what would the family need to prove if their child is actually in a self-contained or a more secluded area, and they would want them to have more general education inclusion, or vice versa? How do they go about making that argument to the district?
Sure. So again, you want to reconvene the IEP team. It's going to be an IEP team decision. And so what the parent, depending on, I'll start with wanting more time in general education. If that is the case, then what the parent kind of wants to concentrate on is, where is their child going to generalize the skills that they're learning through direct instruction? So whether that's behavior, whether it's speech, whether it is direct instruction in reading, writing, or math, where will they generalize that if they are not in the general education curriculum for a set period of time? So that would be the argument for more time in general ed. The opposite, you want, again, it's an IEP team decision, but you have to look at the data. So look at the IEP progress reports. If you think that your child is in general education and needs more of that direct instruction, that is very explicit to your child's needs, you want to take a look at the IEP progress reports. What progress are they making on their goals? If they're not making sufficient progress, or the IEPs are not educationally beneficial, that's what you want to look at. And to determine whether an IEP is educationally beneficial, you want to go back about 3 years, at least 2 years. 3 years is better, and take a look at the progress that is being made towards those goals. If they are not making sufficient or beneficial progress, then that would be an argument for more direct instruction. So you, again, in both cases, you want to take a look at the data, and the data should drive that decision.
So the other specific question is talking about services. If you have a child who is currently receiving some virtual services, either at home or in a district building, but now it's about to move to entirely at home, and the parent doesn't have the ability to provide that internet service, is the school responsible for providing that internet service if the IEP is calling for online classes?
Again, we have to look at the data, right? Again, if the placement is determined by the IEP team to be virtual, then yes, the district is absolutely required to provide the equipment, the internet, supplemental instruction that goes along with being completely virtual. So, and it can be a hybrid. It can be where you're getting your related services in person, and maybe just the instruction is virtual. So it's all going to depend on if it is an IEP team decision, and if that is the district's offer of FAPE. If parents decide to pull their child from the public school and educate them at home, then it doesn't fall under the district at that point. So it depends on the actual situation.
What are the chances of continuing a positive relationship with the school after you filed due process? I hear a lot on retaliation on parents, or just the feeling that in the future, my child's needs or a second child's needs are not going to be met after I have filed due process for a legitimate reason.
Sure. Yes, I mean, it does happen. I'm not going to lie. It does happen. However, that being said, one thing that I pride our department in is that we have been able to establish very positive relationships with school districts, even if due process has been filed. Because if due process has been filed, what your advocate's going to do is going to say, let's take a pause. Let's either adjourn the due process complaint, withdraw it without prejudice, meaning you can refile in the future, and let's try and solve this locally before we ruin that relationship. And especially if you've got a younger child, it is super important to establish a good relationship with the district. You're going to be there for 12 plus years, depending on whether your child stays in school until age 21. So that is one thing that I think that we specialize in, is establishing that positive relationship with districts. I have heard stories where districts go all the way to due process, and that relationship is damaged. I am very proud to say that in all of the cases that we have had where parents have either filed due process prior to hiring us, or we file a due process complaint on behalf of the parents or in conjunction with the parents, we have never had one go all the way to a hearing. And that is because we have been successful at solving things at the local level, whether that's been we've attended a mediation and we come out with a mediation agreement, or whatever the case may be, because our goal is to not get there. And we have managed to, I think, save a lot of relationships between families and districts.
And quite frankly, as parents and families, you're very, very emotionally invested. The first thing they teach you in law school is you don't ever represent yourself in a case, right? Why? Because no matter how good you are as a litigator, if you are personally invested, it's almost impossible to separate your emotion, your passion for your position, and see the forest for the trees. as advocates and as a special education student defense attorney, we act as intermediaries. And oftentimes, the attorneys can come together, or the advocates and the district representatives can come together and reach a happy medium that is going to be very satisfactory to the family, effective, and will sort of dial things down. And oftentimes we find that the districts and the local schools and their principals are happy to have us involved, because it acts as a buffer. And all parties end up being happier with the outcome.
Very true.
I think the last one
Yeah.
is just confirmation that we represent families, students in all of the US states.
Yes, absolutely.
There's
We
no
have,
area
yep,
that,
no, we have clients all over the country. And yes, all 50 states. Okay. All right. I want to thank everybody for joining us and attending. And for those of you who stuck with us all the way through the end, I'm happy that you did. If you need more help, the final slide is our number that you can call to schedule a consultation with a special education advocate, or if you do think you have some disciplinary needs, you would want to schedule a joint consult with one of our advocates and with Nikki as the attorney. And your call screener will go through all of that with you. You will get a cheat sheet emailed email address that you provided for registration with the answers to all of these questions so that you have them in writing. And then also at the very bottom is a promo code, CALDO24, KALDO24, that if you do call in to schedule a consultation, use that and you will get a percentage off. Okay. Thank you very
Thank
much,
you, folks.
everybody. Yep, thank you, and have a great night.
Take care.
Bye-bye.
Bye-bye.